Judge Little's office.
Yes, this is Tara.
Yes.
Hey, Tara, I was calling. I just got off the phone with the Chancery Clerk's office, and I had a couple of questions. Well, they sort of, did not answer the questions. And one of them in particular is in regards to a case that's assigned to your office, to Judge Little, and I was told maybe I could obtain the answer that I was looking for by calling you. And so that's what this call is about. Can I give you a case number on something and see if you can look into something for me?
First of all, could you tell me who I'm speaking to?
Yeah, this is Matthew Reardon.
Okay.
All right. This is in regards to case number 2017 CV217.
I'm sorry, could you give me that number again? I didn't get it written down quick enough.
2017-CV-217. Yeah, dash A, but I don't think the A is important.
Okay, what's your question?
So my question is, I've looked on MEC. There's nothing on MEC about this, and I was calling to ask about the security deposit or the bond that was tendered when this injunction restraining order was applied for back in 2017. Rule 65 of the Rules of Civil Procedure require that a security deposit or a bond amount be given when applying for an injunction, or in this case a restraining order, to ensure that the party enjoined, if later determined to be illegally, that you know it's there for that purpose. And I was inquiring in as to a security deposit or bond, because it doesn't appear that one was ever made.
Okay, where do you say that that's required?
It's in Rule 65 of the Mississippi Rules of Civil Procedure. And the Tannehills, being who they are, they're not immune from paying this. They don't get a free pass on this just because of him being an attorney and her being a public official. And it would appear that they got the free pass on that. And I want to know, you know,
well, the rule actually says in such sum as the court deems proper. So that means it's discretionary to the court.
Well, but if the court is allowed discretion to a certain extent. However, there must be something in writing to that effect. Otherwise, I mean, to just give somebody a free pass and it not be documented or anything written would be fundamentally unfair to
well, Mr. Reardon, that was done by another judge, so I don't have any knowledge of that. And then also, I mean, the time for appealing any kind of decision like that has well passed.
Well, but actually, no, that's incorrect. Because if it was fraud committed upon the court, which would obviously be under a Rule 60B motion for fraud committed upon the court, if there was intentional lies given, if things were fraudulently, falsely represented to the court, the time to appeal, the time to do something about it is not, in fact, over. And I wanted to inquire into this because it is an important question to inquire into.
Okay, well, I've answered your question.
And I also rebutted that as well by showing that Rule 60B.
Well,
I mean,
but
is is this a common practice that whenever it comes to anything against me, Matthew Reardon, that Lafayette County officials, Lafayette County public servants immediately can get complacent and deflect, and if it's and anything illegal can happen to me whenever I'm the party that is on the receiving end of it, and things are allowed to go by unchecked and unchallenged, no matter how wrong they are, how illegal they are. Is that the way that y'all do business? That y'all conduct law there at the courthouse?
Of course not.
Well, it sure sounds that way.
Well,
Because it sounds like you were giving me, it sounds like you were giving me wrong advice, and you were giving me bad advice.
I'm not giving you any advice.
Okay,
I'm
so you
giving
can tell
you
me what happened.
Advice. I can tell you
what happened.
I mean, I can tell you what's in the court file. That's all. Like I said, this happened with a judge that is retired, and I was not working here at that time, so I cannot tell you anything more than what's in the court file.
I know, and it was certainly done conveniently right at a time when Judge Alderson was leaving office, and that was one of the reasons why it was so quickly signed off and pushed through, and then Judge Alderson left. Because,
it was done a year and a half before Judge Alderson left.
Well, and that it was also during that time that I was not allowed back into Lafayette County because of everything that had occurred. But I have uncovered some new evidence of things that the court should be very concerned about, and I can tell that there's zero concern.
There's a proper way to present matters to the court, and a telephone call is not that way.
Well, yeah, and you're right, there is, and there is a proper way. But being that I can't come into Lafayette County,
I tell that to anybody that calls into the court and asks questions the way that you have.
I understand. I'm also a journalist, and I have different ways of obtaining information that, not only am I a journalist, but I've learned enough law that I might as well be an attorney, but I'm not an attorney. I'm not, I've self-represented in this case. I've had to learn the law, which is how I was able to cite the law to you on all that, whenever you tried to tell me that it's beyond the time to do anything about this.
Well, Mr. Reardon, if you feel like that it's not beyond the time and that you have an avenue for relief, you may certainly take it.
Well, I just don't. I mean, the problem here is, I had an avenue for relief whenever I was fraudulently committed, whenever I served you and Judge Little with the formal notice about what Communicare did, and none of that ever mattered back in 2022. That was a cover-up that happened back then, and I have absolutely no doubt in my mind that it'll be a cover-up here that happens, that it'll be completely ignored, it'll be completely condoned, because hey, it's Oxford's first couple, dealing with Mayor Tannehill and Ray, but it amazes me how.
Well, Mr. Reardon, from what I can tell, it looks like the restraining order was dissolved in 2022.
What?
No, I'm sorry. No, I'm sorry. That was a motion that was filed. I'm sorry.
Yeah, it was a motion that laid out a lot of things on why it should have been dissolved. Absolutely, but Judge Little didn't really care for the facts in it, even though it was made. It should have been taken seriously. Certainly, it should have never been taken out in 2017.
Mr. Reardon, I also remember how you acted in court that day.
Well, if you were on the receiving end of the same things that happened, you would be pretty damn pissed off as well. So, I just, this type of stuff is, it's not going to be allowed and not going to be condoned, and I just I wanted to hear from y'all, from the judge's office, if there was anything else that you saw about a security deposit or a bond ever being given on this case when this illegal restraining order was taken out back in 2017 that they knew was illegal and was based upon complete lies and fabrication and constitutionally protected activity. Have you had a chance to read the restraining order back in 2017, or did y'all just take it at face value from Judge Alderson?
I'm sure I read it back in 2022.
Well, it's shocking that you look at the things that are in there. I mean, it's an embarrassment. I can't believe that if I was a public official, I would be embarrassed to put the stuff in there that was in there that was relied upon for getting it. And then, and to make matters even worse, the only other things in there that were not constitutionally protected can now 100% be debunked as lies. Did not happen. And in fact, the one that petitioned for the restraining order was actually the one that issued threats of extreme physical harm, and there are police reports of it. I've actually obtained law enforcement reports of where the petitioner actually threatened harm on me. So he can't show a single bit.
As I've stated, Mr. Reardon, if you feel like that you have an avenue for the relief that you're requesting, there is a way to seek that, and that's what I would suggest that you do. I mean, making your arguments to me does not further your case in any way.
Oh, I know. It does nothing to help it. In fact, it probably actually hurts it, because then it gets you upset. You're probably going to talk to the judge, and the judge is going to be, once again, be adamantly against me. But he was already against me before, so that doesn't really matter. But yeah, I mean, you're right. It does nothing other than, it gets some things off of my mind that I wanted to get off of my mind about all of this, and try to get to the bottom of whether or not there was ever a security deposit or a bond ever given by Ray Tannehill when he took out this restraining order, or the fraudulent restraining order back in 2017. I can't even call it a restraining order because that's giving it too much credit. I appreciate it, Tara. I know this isn't getting anywhere. I just needed to, I wanted to see if you could give me any information.
Okay.
All right. Take care.
You too.
Bye-bye.
So with that call, I found out several things, several very important things, okay? First of all, as I figured, no security deposit or bond was ever paid by the Tannehills when this restraining order was turned in, okay? And this right here, if there was one, she simply would have said it. But instead, it was a deflection to, well, what rule do you say that this is required? And then she said, she tried to poise it as it was discretionary. And as I said on that call, okay, this gets into issues of fundamental fairness when it comes to others. To have discretion to make some people pay it, but not others, is a major issue. Here you have somebody that is running for mayor. There's no financial issues. There's no reason why the court would waive the cost for indigency or anything like that. There was just never one paid. That is a major, major issue for this restraining order. The other issue that came up during this call is the fact that Tara said on the phone that it was too late for me to do anything about it, which shows several things right there. It shows how easy Lafayette County is to stick it to me and say, woe is you, it's too late, you can't do anything about it. She gave me legal advice on the phone right there, in saying it's too late for me to do something about that. She was actually trying to discourage me taking any legal action on that. There's no way that that can be seen as not giving legal advice. If I didn't know any better and if I didn't check that, I could have gone at that word and not done anything about it. Stay tuned on this issue. This is a developing story with Lafayette County.